Thank you, Carrie. Welcome to today's webinar, When Victims of Battering Are Charged with Crimes, Helping Victims Defendants Navigate Concurrent Protection Order Proceedings. This is the third webinar in a three-part series. If you have not been able to view the previous webinars, we will post a link to access these webinars in the chat box. And you can also access these webinars by going to the National Clearinghouse for Defense of Battered Women. We will be collecting questions in the chat box throughout this presentation, and we're hoping to leave 15 minutes at the end of the webinar to answer any questions as time allows. This webinar is being co-sponsored by the National Center on Protection Orders in Full Faith and Credit and the National Clearinghouse for Defense of Battered Women. The National Center on Protection Orders in Full Faith and Credit is funded by the Office on Violence Against Women, and we provide training and technical assistance on all issues related to issuance, service, and enforcement of protection orders, enforcement of federal and state firearm laws related to domestic violence, and the federal domestic violence and stalking crime. Our presenter today is Cindene Pezzell, Legal Coordinator for the National Clearinghouse for Defense of Battered Women. In addition to overseeing the current legal team, she provides direct technical assistance to defense teams and researches and develops legal materials. Cindene is an experienced trainer who develops and conducts training materials and programs for around the country on topics related to advocating for and defending charged and incarcerated victims of battering. She also provides expert testimony on behalf of victims of battering. Prior to joining the Clearinghouse, Cindene worked at the Defender Association of Philadelphia, where she represented people charged with crimes. Welcome, Cindene.
Thank you, Monica. I appreciate that introduction, and I am happy to talk with you again about work related to victims of battering who have been charged with crimes. I have seen many of your names pop up for the past two webinars, so I'm really glad that you're here again. But even if you haven't been here before, I hope that today's material is of assistance to you. Now, in the past, we were talking about some pretty, pretty broad overviews and some specific advocacy strategies related to working with victims of battering who have been charged with crimes. And today we're going to pull that focus in a little bit tighter and talk about victims of battering who are simultaneously involved in multiple court systems, including the criminal legal system as a defendant. Before we do that, though, I do want to tell you a little bit about the work of the National Clearinghouse for the Defense of Battered Women. We work on behalf of victims of battering who have been charged with crimes. We provide direct technical assistance to the legal teams of charged victims, meaning that we work with defense attorneys, expert witnesses, community-based advocates, and other people who are coordinated together to make sure that victims facing criminal charges are given the best representation and support possible. We do this on an individual case basis. So our work is case-specific, and we do that work throughout the country in all 50 states, in federal courts, and occasionally we consult in tribal courts as well. We will work with victims involved in the criminal legal system at any stage, including pre-arrest. For example, somebody who suspects they may have warrants issued for their arrest, and will work all the way to post-conviction, including clemency efforts, efforts to get somebody's sentence reduced or excused after they've already been convicted. So we'll come in at any stage if we can be helpful. And we're really happy to be talking with you here today because this issue is one that comes up whether or not you work primarily in the criminal legal system or whether you work in the civil legal system. We're seeing this kind of overlap all the time, and it presents some special challenges, and that's what we're here to talk about today. So we're going to start by discussing ways in which victim defendants might be involved in protection order proceedings in the first place. In other words, how people end up with one foot in the criminal courtroom and one foot in the protection order courtroom. There's a lot of different ways that can happen, and how that moves forward is definitely going to have some impact on the most effective representation and advocacy strategies for those individuals. That being said, we're going to talk about the legal implications of seeking a protection order for victims who are criminally charged. I think for community-based advocates, this is most often how this issue comes up. At least that's what we here at the Clearinghouse hear most about. We'll hear about a person who was arrested, for example, for defending herself against her abusive partner, and she wants to seek a protection order based on the circumstances that gave rise to that arrest. Is that the only way that these simultaneous proceedings can happen? No, and we'll be talking about some of the other ones as well. And finally, we're going to be talking about some advocacy strategies that can be employed to make sure we're providing the best services and support to victims who are involved in criminal court and protection order court at the same time, and make sure that our well-intentioned interventions are helpful and definitely are something that are not going to cause further risk to her legal options. Throughout the discussion, I know I kind of always begin with this, but it's particularly important today to talk about what the language is going to sound like today, because there are definitely traditional ways of addressing parties in civil and criminal cases. And so to avoid confusion, when I'm using the term survivor or victim, I'm always talking about a survivor or victim of ongoing battering. I'm not referring to whether somebody's a defendant, a complainant, a petitioner, or a respondent. I'm talking about whether or not somebody's a survivor, because as we've talked about many times now, we know that your position in civil or criminal court doesn't determine whether or not you're a survivor of ongoing battering. If I use the term petitioner and respondent, I'm specifically talking about somebody's legal positions in court proceedings involving civil protection orders. A petitioner is somebody who is seeking an order against somebody else in general, and a respondent is somebody who is responding to that petitioner's seeking that order. Okay? So again, that does not give you any information about who has used abuse against a partner. All that does is tell you what their position is in that civil proceeding. And similarly, in criminal court, even though the criminal legal system tends to use phrases like victim, perpetrator, and defendant, I'm going to be sticking with victim to refer to victim of battering, and complaining witness to refer to the person who is alleging that they had a crime committed against them by their abusive partner, or excuse me, by their partner. So, as I said before, we can't really look to the information, to the labels that somebody is assigned by the legal system to tell whether or not they are a victim of ongoing battering. Victims can be defendants just like they can be respondents, or they can be complainants, or they can be petitioners. So that language is something that we're going to use, again, to talk about legal position and not about whether or not somebody's experienced battering. So I said that we were going to get into this pretty early on with a discussion about how somebody who has criminal charges against them can intersect with the civil protection order process. And these may not be all the ways here, and it might sound, when we're talking about this, going through this list, some of you might ask yourselves why this even matters. And the reason that it matters is because it's going to impact what our best interventions look like, but it's also going to help us make sure that we're looking in the right places when we're doing our representation and our advocacy. In other words, just because somebody is not, a defendant comes to you, she's not already involved in the civil protection order process, she might become that way at one point. Just because she's a defendant doesn't mean that that's not necessarily going to happen. So it could happen where somebody gets arrested and she and her abusive partner were already involved in the civil protection order process. And what I mean by the process is, maybe they're at the stage where somebody has filed, but there hasn't been an order issued, or maybe there's been a temporary order issued, or maybe they're even in the appeals process where an order has been issued and one of the parties is appealing it. So that can definitely happen. We see that all the time. We see defendants get arrested who either have protection orders against them, temporary or permanent, or their abusive partners do. When this happens, that protection order was generally based, most of the time it was based on something that happened before the incident for which somebody ended up being charged with a crime, but that's not necessarily always true. For example, an incident could happen, a party could seek a protection order, and a warrant could get issued for somebody's arrest, but if that warrant's not executed for another 6 months, that might mean that somebody's been under a protection order for an incident that they didn't get arrested for a long period of time. So if we're trying to line up, the facts that support a protection order and the facts that are alleged in a criminal case, we can't always look at what looks to be the logical timeline is to do that. We're going to have to see what the allegations are in the paperwork itself. It can also happen where a complainant goes to court and files for a civil protection order based on the same incident for which the defendant is charged. We see this happen an awful lot, and we know that there's a lot of communities in which when the police respond to the scene of a crime, whether they make arrests or whether they don't, the person that they've identified as the victim of that incident, they will advise them to go seek a civil protection order. Maybe the victim does that with the help of a local program. Maybe they don't. Maybe they think they have to, or maybe they just simply want one. But, police arriving at a place where a crime has been alleged can often be the trigger for involvement in the civil protection order process. It can also happen, and it does happen all the time, where a complainant files for a civil protection order based on an incident other than the one that the battered defendant was arrested for. I think the dynamic in this situation is that once an abusive partner, kind of gets an idea of the ways in which he can leverage court systems against his victim, he or she is going to go ahead and use that to the fullest extent they can. Oh, wow, I was able to get her arrested. I can do this other thing, too. I can get a protection order. And they can, at least attempt to turn what is supposed to be a tool of protection into a tool of abuse, which we will talk about a little bit more later. It can also happen, and this is what I referred to before, where a defendant wants a protection order for the same thing she got arrested for. This can get really complicated, and we're going to spend some specific time here talking about the different pitfalls that need to be navigated if you're working with a victim defendant who really wants a protection order, and the allegations she's going to put in that petition are the same ones that gave rise to her arrest. And then, of course, she can also seek an order based on an incident for which she, not the one that she was arrested for, but for something else entirely. Again, we're going to cover this, and it might not be as complicated as it is, as it would be if it was the incident she got arrested for, but there are still going to be some important things to consider moving forward. So as I alluded to a couple of minutes ago, it's important for us to really kind of take note when people we know to be victims of ongoing battering are respondents in protection order proceedings. A protection order can really be a very, powerful piece of paper in the hands of an abusive partner. There's a lot of things that an abusive partner might find that he can do to exercise coercive control over his victim if, in fact, he is armed with a protection order. First of all, an abusive partner can use a protection order as leverage to get what he wants from the victim, whether that's sex, whether that's a visit, whether that's access to the children, whatever it is, the threat of accusing the victim of violating that protection order is a really powerful threat. Because as we know, a violation of a protection order can result in all kinds of sanctions, including, but not limited to, criminal charges, arrest, and incarceration. Another important thing to remember is that if a victim is subject to a protection order herself, the police aren't going to necessarily be a very attractive resource of safety for her for fear of being arrested. I'm sure many of you have seen the scenario where a victim is in the same proximity as her abusive partner, which is against the strictures of the protection order that she's the respondent in. And so if he's abusing her, if she calls the police, they arrive on the scene, they find out she's in violation of an order, even though he is abusing her, is he likely to be the one who gets arrested, or is she? There's also definitely situations where people who are respondents are prohibited from participating in programs, and I'm really talking specifically about programs that are designed to help victims. Because unfortunately, there's, sometimes programming is structured in ways that excludes people as perpetrators of domestic violence based only on whatever label they were given going through the court process. So if somebody actually has a protection order against them, there might be situations where they can't go to victims group, or they can't participate in group counseling sessions, or whatever it is. That can be a huge barrier for people. The credibility issue is huge for people with protection orders against them, and this is something that I learned over and over and over again in my time as a public defender. Somebody might not have, so much as a traffic ticket on their criminal rap sheet, but the existence of a protection order, if the police find out about it because it was properly entered into the local database, the existence of a protection order is going to have an impact on the decision-making that happens when police show up after they get called to respond to a domestic violence incident. So if somebody has a protection order against them and somebody doesn't, I'm not saying every time the person with the order against them is going to be the one who gets arrested, but I think the chances go way, way, way up. And arrest decisions aside, the story, the statements that people are giving the police on the scene seem much more likely to be believed by somebody who's not the subject of a protection order over somebody who is. And then there's the whole very problematic aspect of the likelihood of subsequent arrest. This is related to my last point about, who the police are going to believe if they respond to a domestic violence incident. But it's just important to look at that coupled in with an abusive partner's ability to use that protection order as a tool. Because abusers can and do this. They get their victims arrested, and having a protection order against somebody makes that even easier. So now you don't just have to convince the police there's probable cause. If you can coerce your partner into what appears to be a violation of that order and then call the police, that arrest is really, really likely to happen. And that's a lot of power in the hands of somebody who batters their partner. So some people might be asking how victims even end up under the circumstances where they would have protection orders against them. And it's important to spend a couple minutes here because I just don't want people, to miss the wide range of ways that this could happen. Sure, I mean, I think Are there situations where the court gets it wrong? Sure, there definitely are, but I really don't think that the majority of victims who have protection order cases against them, I don't think it usually happens because the court ends up making a wrong determination. There's just so many other ways that it could also happen. So yeah, could an abusive partner file for a petition against his victim or her victim and go into court and absolutely lie, and the court believes them and they get an order? Sure, that can definitely happen. The same thing can happen where, a petition is completely fabricated by the abusive partner, but the victim has every reason not to go into court and say that it's fabricated. So maybe they, either don't show up and get a default order issued against them, or maybe they just agree to the order in court. And, as you can imagine, from your respective perspectives and roles, there's a lot of reasons that victims might quote-unquote choose to do that, Are they in a position where they can ever contradict their abusive partner's word without severe consequences? They just might not be. Like, agreeing to an order or not showing up to court might be the safest option in responding to a lie by the abusive partner. It can also happen, and we've seen it a million times, even though in a lot of jurisdictions it's frowned upon, if not disallowed, where a court will issue a mutual order against a victim who is seeking a protection order with the rationale that either she gives as good as she gets or that a mutual order will be most protective of all parties involved. Any advocate or practitioner who spent 5 minutes in the civil protection order world, knows that mutual orders don't do anything to increase the safety of victims and can, in fact, have detrimental consequences to the safety of victims. But I just think there's a mythology, not in all places, but in some places with some judges, that if both parties have legal strictures against them, that contact is never going to happen again and everything's going to be fine. And we know that that's just not how it works in the real world. Now, this one's important. It can also happen that the abusive partner meets his or her legal threshold in court. And I say this because I really want to go back to emphasizing the point that victims who end up with orders against them, it's not always because the court gets it wrong. Victims might do a lot of things to survive their abusive partners, and sometimes those things might be against the law, and sometimes those things might actually be scary. So we've definitely seen situations where a victim uses what we might classify as self-protective force against her abuser, but a court would classify as a legal force, and an abuser is able to obtain a protection order on the basis of whatever that action was. So my point is that just because somebody's an abusive partner does not mean that there are never going to be circumstances where they could meet the legal threshold requirements to get a protection order against their victims. Is that a good outcome? No, of course it's not. It fails to consider context and ongoing safety, but it's definitely a thing that's possible, and so we need to make sure that we keep our eye on that particular ball. This last one, I've already alluded to it, but it's huge, and as a public defender, I saw it over and over and over again. An abusive partner seeks a protection order, and the victim just goes ahead and agrees to it. I brought this up a second time, not to be redundant, but because it kind of, when this happens, this might not be about whether the allegations are true or false or provable or not provable. This might be either because it's a safety strategy on behalf of the victim, or, and we'll talk about this more in a minute, or because that's the advice that the victim gets by counsel. And that can happen in a couple different ways. We're going to talk about legal risks that victim defendants can encounter in the civil protection order proceeding, which will kind of illustrate why people might agree to orders that they really shouldn't be subject to. So we'll get there in a few minutes. But right now, what I want to talk about is a hopefully dying mythology that I was definitely that I definitely witnessed and experienced as a public defender, and that is the mythology that if you don't want to see him anyway, agreeing to an order has no downside. I know there's a lot of people probably on this call right now who are like rolling their eyes or gasping, but that is something that people, actually believe, and that's something that as a public defender, before I worked with a number of victims who have been charged with crimes, that's probably some advice I can see myself giving. We're coming from we're being prosecuted for something you're accused of doing. One of the ways that we might make that prosecution more favorable, or we might make your punishment less bad, is to agree to a protection order. And what's the downside? You don't want to see him anyway. You're going to be on probation anyway, so it's really not going to affect your life at all. And that is categorically false for all the reasons that we've talked about, mostly because of the enormous amount of power that a protection order can give an abusive partner. And because that's the third or fourth time I've used that phrase, I want to pause for a second to acknowledge that, we have this kind of, catch-22 isn't the right word, but we have this kind of bizarro situation where for a lot of victims who have protection orders, for a lot of people, that piece of, I wouldn't refer to it as just a piece of paper, but some people do, and that piece of paper doesn't have very much power because abusers are not all abusers are necessarily deterred by protection orders. They don't conform their behavior to protection orders. So how is it that when the tables are turned and the abusive partner is the one who's on the petitioner side of the document, how is it that it then has so much power? And I think, it's because, not because of the necessarily the power of the document itself, but because what the abusive partner is going to go ahead and do with it. So I point that out just to say that I acknowledge that, it's a different way to be talking about protection orders as extraordinarily powerful documents when over and over again, we've all worked with victims of battering for whom those orders were not as powerful and protective as we needed them to be. So I talked about some of the reasons why somebody, might just agree to a protection order, including doing so in order to get a more favorable disposition in court, especially when a criminal case and a civil case are connected. And I've talked about, maybe somebody who might agree to an order because they're afraid of their abusive partner, but there's some other reasons too. Just like any court system, civil protection order proceedings can drag on and on and on again. And, just like any other court proceeding, we know that causing proceedings to drag on and on again can be a tactic of abusive partners to not only control their victims, but to also give them, a chance to be in the same room with them, to see them, to even share words and time with them that, that victim might be compelled legally to participate in. So by agreeing to a protection order, maybe a victim doesn't have to worry about going back to court 45 more times or to be subpoenaed to come in and defend herself against the petition or whatever the case may be. I think, the thought is if I agree to this now, maybe it's true that I never have to see this abusive partner again. I've already mentioned belief that, this completely false belief that agreeing to be bound by the strictures of a protection order is not something that can hurt you unless you're going to violate it, and maybe it could even be helpful. Another note to make on this point, and I think many of us have seen this play out in courts around the country is the idea that the two parties in a protection order are bound in the same way by that protection order. We know that's not true. It's only the respondent who is bound by the requirements of a protection order. But I don't think the misinformation only happens, by judges in courts who try to hold victims in violation of their own protection orders. I think that it is reasonable to assume that parties might also think that if, somebody's not allowed, if they're not allowed to talk to somebody, that somebody's not allowed to talk to them either. So agreeing to a protection order might be seen as some who don't have all the information as a thing that can actually be affirmatively protective of them, and we just know that's not true. I'm sure there's other reasons as well, but I think the takeaway point here is that really there are lots of legitimate reasons, perhaps based in safety, perhaps based in something else, that a victim might agree to be subject to an order. But that agreement doesn't do anything to negate or diminish her position as somebody who is a victim of ongoing battering. In other words, just like being arrested doesn't make somebody unbattered, agreeing to be bound by a protection order similarly doesn't make somebody unbattered. As I mentioned, looking to whether or not any particular behavior is legal or illegal is definitely not going to give us the full picture over who is an abusive partner in a relationship. So it's always important not just to look at where somebody's sitting in court, not just to look at what somebody is accused of doing, even if they did it, but to look at the broader context of relationships so that we can make sure that victims are getting our support and our services, even if they find themselves on the more complicated side of the courtroom. So I'm going to pause for a slight water break here. Okay, excuse me. So perhaps the most protective thing that a victim can have when he or she is involved in multiple court proceedings is complete representation. And I know that it's a tall order for all of us to envision a situation in which a victim who is involved in multiple court proceedings has lawyers in all those proceedings. And not only that, but lawyers who specialize in whatever those proceedings are. So criminal defense attorneys for the crimes for which she's being charged, civil attorneys to defend her against protection orders who, are experienced in representing victims and, understand the nature of battering and its effects, and attorneys in all other proceedings as well. This obviously is aspirational and it's important and it's something that we always want. And so it's a little bit of a no-brainer, but I bring it up here to say that while every victim of battering who is involved in protection order proceedings could potentially benefit from having a lawyer, that need is particularly high from people who also have open charges, and that remains true even if they're lucky enough to have an advocate who is working with them. And the reason that that's true is that not only do you, is a survivor facing the risks that we have talked about, some that come with being the respondent in a protection order proceeding, they have the risks that come with being a defendant in the criminal legal system. And if there's anything that happens in the civil system that can undermine that criminal system, and we'll get to ways that that can happen, then we're not just, we're not necessarily talking about risking being found in contempt. We're talking about incarceration. We're talking about being under state control. We're talking about freedoms being stripped, somebody getting a record, somebody facing all the consequences that come along with being someone with a criminal record. So advocates who are working with victims who are involved in these proceedings proceedings simultaneously, can definitely play a crucial role in making sure that in both systems a survivor's rights and options are protected. Sometimes an advocate is the only way to ensure that that happens. And before we get to some of those, kind of concrete advocacy strategies that can be employed, we'll talk about why the risks are so high. Now, going back to something that us at the Clearinghouse talk about over and over again, it is true that what a defendant says can be used against him or her in criminal court. Now, take that and times it by 1,000 when that person says that thing in another court proceeding. Okay, so imagine, you're in civil court and somebody's writing down everything you say, and you talk about what happened to you. If that incident is the same incident that you're in criminal court for, or sometimes even if it's not, but it's a related incident, of course those words, can be brought over to criminal court and potentially used against you in your criminal proceeding. And this, this can definitely get incredibly tricky. And when it gets the most tricky is when the incidents that bring the survivor to both of those proceedings is the same incident. So, we'll get to some case examples that were based on real examples in a few minutes here, but, imagine, not wanting to implicate yourself in your criminal case, but not being able to defend yourself in your civil case because you don't want your words to then be used as a weapon against you when you're facing your criminal court proceeding. That's the situation that survivors can often find themselves in. So again, what you say in criminal court can definitely be used against you in civil court. And so we'll talk about ways to kind of mitigate the impact of that happening or even the opportunity for that to happen. But that's just one thing to always be on the lookout for. And, quite frankly, while we're on this subject, that, it can definitely easily go the other way as well, and we'll have an example that kind of bears that out. The reason that I frame it the way that I do about impacting the criminal case is because of the consequences of a criminal case. But, if somebody's done something in criminal court, can it be brought into civil court, and maybe be used to impeach them or contradict what they say? Perhaps. So the risk goes both ways. But it's just important to remember that we need to keep our eye on where the consequences are more dire when we're figuring out how to advocate so that cases move forward in a way that minimizes legal risks to the survivors that we're working with. Another thing that can happen is that findings by judges can influence outcomes in other cases. This is, it's not so much a rule that this happens, but it's something that we observe happens in communities, especially in small communities, and perhaps in communities where there are, these centralized justice centers that handle civil and criminal and CPS cases and custody cases and all these things at once. Even if there's going to be some legal shields protecting what happens in one proceeding from getting used in another proceeding, the reality is that judges often know what's going on in various cases, and whether they want it to or not, that can definitely have an impact on how they might rule in a particular case. Like if you know that somebody's already pled guilty to a certain set of facts, and then somebody's trying to get a protection order based on that, as a judge, what kind of impact is that going to have on whether or not you are now viewing their testimony that they didn't do it as credible? Okay? So it's just kind of important to remember the human factor, too, and how one outcome can influence another in the circumstances in which fact finders kind of know what each other are up to. And of course, that gets mega amplified when you have the same judge that is presiding over various aspects of somebody's involvement in legal system. So if the same judge is hearing your criminal case, who is hearing your protection order case, who's hearing your custody case, that can bring with it its own unique set of risks, and that can probably be its own webinar. There's also the leverage question, and on the slide I'm talking about leverage by the victim, but there can definitely be leverage by the abusive partner as well. In a lot of communities, especially, there's actually rules as this isn't supposed to happen, but we know that it does, where if there is a civil case and a criminal case related to the same incident, negotiating one of those cases might have a positive or negative impact on what happens with the other case. So knowing that it's, and the best example I can think of is what used to happen when I was a public defender, not uncommonly, which is, there would be situations where if my clients would agree to a 3-year no contact civil protection order against them, then the criminal case might go away. Or it would go away because that was the agreement in front of the court. So I'm not saying that can happen in every community, but there's a lot of communities where that can happen. And so kind of knowing what the options are and being able to minimize risks and being in a position to make sure that all parties have the same information so that those decisions can be made is just a really vital and important role that an advocate can play. We hear this phrase all the time, timing is everything. Well, that's definitely true. What case ends up proceeding first when somebody has a civil case and somebody has a criminal case can matter, and it can matter an awful lot. Now, sometimes there's absolutely nothing that people can do to have any influence on whether, on when their cases get heard in court, but sometimes there are. They can ask for continuances. They can, ask for delays in court proceedings to get attorneys, whatever it is. Sometimes there's some ways in which people can try to ensure that one proceeding goes before the other one. And in general, although not always, which we will talk about, it is usually better if the criminal case goes first. That way, there's not this opportunity for whatever gets said in the civil protection order proceeding to be used against the defendant in the criminal case. So the criminal case ends up, with its attendant risks, including incarceration, fines, punishment, state control. That goes first. There's nothing that's previously been said on the record that can implicate the defendant, and that gets resolved however it gets resolved. Once that happens, then it's a little bit safer to then go forward with the civil proceeding, even though it remains true that evidence from the criminal can affect the civil. But that being said, though, there's another potential benefit that can sometimes be on the behalf of, be raised on behalf of the defense when the criminal case goes first. And sometimes there's a criminal protection order proceeding that accompanies whatever outcome happens in criminal court. So let me say that a little bit more clear. Say, for example, a defendant gets placed on 3 years of reporting probation. It could be that a condition of that probation is no contact with the in the case. And if that is in place, then maybe the petitioner for the civil protection order will not feel it's so necessary to go ahead and try to seek that separate civil protection order, and the case can be resolved that way. So that can definitely happen. The other reason that it's usually helpful to have this criminal case go first is because criminal court has a higher burden of proof. It might be that a criminal case doesn't generate any testimony at all by the defendant, and often, in fact, that's true. And sometimes defendants can even win that way. What I mean by that is that the prosecutors have to prove their cases beyond a reasonable doubt. Now that means the defendant's not required to say anything. They're not required to give their side of the story. They're not required to speak in their own defense. If the prosecutor cannot make out that a crime occurred and that the defendant was the one who did it, that case might go away without the defendant ever having to put anything on the record at all. The same is not true in civil court. In civil court, for a petitioner to show that something happened, the burden is much lower. So there's no, while it's possible that a petitioner could go into court, make a record, and the judge could say, oh, you didn't give me any reason to believe a protection order should be issued, it's going to be more often true that in order to try to prevent a protection order from being issued, the respondent has to actually say something and put something on the record. So in general, doing what can be done to delay that protection order proceeding until the criminal proceeding is over is almost always the way to go. But as with any rule, there's always going to be exceptions to it. And I've worked with some defense attorneys who have really been able to use protection order proceedings to their victim, defendant, client's benefit. If you have a complainant, an abusive partner who's just lying his head off and making things up as he goes along, then it might actually be a good strategy to try to get him locked into a story by proceeding with the civil protection order proceeding first, if that proceeding is in relation to the same incident for which the charges were issued. And what I mean by that is, if he says something to the police believe him, they lock the victim up, now if he's making it up as he goes, now he has to put something on the record. And maybe he gets the protection order or maybe he doesn't. But he also has to then go into criminal court and try to tell that story again. And any, savvy defense attorney is going to have a copy of that testimony that he gave in civil court and be able to impeach him on the basis of it. So that can be, a legitimate strategy for wanting to go ahead and delay that criminal court proceeding past the civil. The other potential benefit, and we've seen this at the clearinghouse as well, is that civil court can be a really helpful discovery opportunity for the defense, particularly in cases where there's not a lot of discovery generated. And by discovery, I mean victim statements, police reports, photographs, the kinds of physical evidence that the prosecution uses in order to try to convict a defendant and that the defense is entitled to use to prepare before the case goes to trial. Sometimes there's just not a whole lot of that stuff. So defense, is often in the position of having to, investigate and generate discovery of their own. Maybe they send investigators out to interview potential witnesses, that kind of thing. Well, that can happen in civil court. Maybe you have a really high-stakes criminal proceeding that's pending, and you have a civil case where the stakes aren't quite so high. You can put a witness on the stand and get their testimony and have it be something perhaps usable to you to help out your case in that criminal court proceeding. So, yeah, exceptions to every rule, but in general, to the extent that we can make sure all parties have, in this context I'm talking about people who are advocating for and representing her in civil court and criminal court, making sure everybody has all the information about when cases are happening and what's going to be alleged in those cases. By doing that, advocates can really help make sure that the cases move forward in the order that'll be most beneficial to the defendant, if that's all possible. Sometimes it's just not so clear what orders we're talking about when we're talking about criminal defendants and protection orders, because as I mentioned a few slides ago, there are such things as criminal protection orders as well. In some states they're called no contact orders, in some states they're called restraining orders. But anyway, these are orders that are issued by the criminal court and not by the civil court to accompany criminal court proceedings in some way. And what I mean by that is, a judge could make it a part of somebody's bail conditions that they don't have any contact with the complainant in that case. Or a judge could decide that as part of probation or parole conditions that somebody not have any contact with the complainant in that case. I'm pointing this out for a couple of reasons. One is to not get the procedure piece confused. These orders, there are sometimes opportunities for defendants to contest them in court, but they don't have the same kind of process that the civil protection orders do. And that's because, they're always attached to some kind of set of restrictions or provisions from the criminal case. So you might be able to argue to the judge that you shouldn't have this order against you, but you're not going to get a whole separate court proceeding on it. And that being said, once a criminal case is over, if the case is over, you're not on probation, you're not on parole, you can't really have a criminal order anymore. So they can only accompany the criminal case for as long as the defendant is under the power of the criminal court system. So unfortunately, there's definitely survivors that we worked with who are subject to both civil and criminal orders, and sometimes that doesn't necessarily impact what a survivor is or isn't allowed to do, but sometimes the orders are not consistent. And this can be incredibly frustrating for somebody who's really trying to, stay off the radar, stay out of trouble, and follow their orders to the letter. When those two orders are not consistent, it's hard to know kind of what to do in terms of making sure that you don't end up with a violation. I think the most consistent, inconsistency I've seen are different custody provisions in a civil order and in a criminal order. For example, say for a moment that somebody is charged with assaulting their abusive partner, their children are present. So the criminal court judge issues a zero contact order against the defendant, saying that she can't see her partner or her children while the case is pending. Well, maybe she already has a civil order that gives her custody, or maybe she even has a separate custody order. Which of these three sets of judicial instructions is she supposed to follow? The reality is that she's expected to follow all of them, even though sometimes that's, not factually possible. And this can be a real source of frustration for people, and it's definitely a situation where, to the extent lawyers can get clarification, that can just be so helpful. But a lawyer is not going to know to ask the court for clarification unless, there's somebody there to point out that these other orders might already exist. So again, another crucial kind of pivot point for advocates is, knowing what's up in the lives of, especially the legal lives of the survivors that they're working with. So that maybe when a criminal court judge tries to drop that order, the defense attorney is in a position to say, hey, there's already an order in place, and this is what it says about managing the children. Can we make this order consistent? That can be incredibly helpful and, help to minimize at least a little bit the chances that somebody's going to get violated for not obeying criminal court orders. There have been states that have tackled this issue, so it's important to kind of know the jurisdiction that you're in. For example, the state I'm thinking right now is California. I'm pretty sure they have a statute that controls the precedence that orders are supposed to be given. If you have two contradictory orders, this one is the one you follow. Now, I can't remember which one is which, but at least there's some guidance for survivors who find themselves in that very, very tricky position. So, even if an advocate who is working with a victim defendant, maybe, whether or not they're necessarily connected closely with that victim's attorneys, if they're not, what they can do is help victims make sure that they're asking their lawyers about different orders and what to do if they find themselves in a situation where orders contradict one another, and how to resolve that and get them to be consistent if at all possible. So I said there would be case examples, and I'm going to start with one now. I'm going to read it out loud, especially because I know there's people who can't see the webinar right now. Maybe they're just on the phone. So we're going to be talking about Donna. Donna gets arrested after striking her abusive partner in self-defense. While she is still in jail, he files for a civil protection order against her. Donna testifies at the civil protection order hearing and explains to the judge that she did in fact hit her partner, but only because he had threatened to slap her stupid. The judge issues the civil protection order against Donna. Now, I would imagine that that scenario doesn't sound too unfamiliar to very many of you. What we have is a situation where a survivor has acted in self-defense, and maybe the way that she phrases it to the judge or to her lawyers or to her advocates or whomever doesn't necessarily cast the incident in the most favorable light, legally speaking anyway. So imagine that situation. Now Donna has a civil protection order against her. She's already told the judge that she did in fact hit her partner after he threatened her. Well, then Donna's abusive partner doesn't show up for the criminal case. While such a case might ordinarily be dismissed due to lack of evidence because the abuser isn't there, the prosecutor decides to proceed anyway and uses Donna's testimony from the protection order hearing to argue that she is guilty of assault. Okay? So this is a very real possibility here. You might have a case where a prosecutor doesn't have anything because the abusive partner / complainant isn't cooperating, but because there's something on the record from another proceeding, they can move forward anyway. So that is a huge risk and an example of why, normally speaking, it's good for criminal cases to proceed first. Let me give you another example. Now we're talking about Roxy. Roxy files for a civil protection order after her abusive partner strangled her. While that case is still pending, she gets picked up on an arrest warrant. And she finds out that the arrest warrant was issued because her partner told the police that Roxy had attacked him and showed them scratches all over his hands and arms. Now, Roxy quickly pleads guilty to a misdemeanor harassment charge so that the felony against her for attacking her partner would get dropped, and she gets sentenced to time served and gets to go home. But now she still has to deal with this civil protection order proceeding, and her abusive partner uses the fact that she pled guilty as proof that she's the aggressor in the relationship, and not only is she the aggressor, she admitted it by pleading guilty in the other case. So she's not able to get her protection order. So those are just 2 of thousands of examples of ways that civil protection order cases and criminal court cases can impact one another in ways that are really detrimental to survivors for both their legal options, like as in the first case, and their safety options, as in the second case, where a survivor who really wanted a protection order wasn't able to get one because of her criminal case. It bears repeating that for survivors who are respondents, there's an incredible toll that can take on safety and on legal rights and options. And this isn't anything I haven't said already on this webinar, but the vulnerability factor goes way up if somebody's abusive partner not only has the physical, financial, psychological, and emotional power to coerce and control them, but has the legal power to do so as well. And I don't think that can be emphasized enough. So we're going to spend these last 12 minutes or so talking about some more advocacy strategies. I have tried to weave some in as we've gone along. Obviously, I've talked about this first one already, and again, I know this is pie in the sky in a lot of places, but Helping victims get civil attorneys, if possible, is always important, but if they're also defendants in criminal cases, I would submit that it's extra important. Advocates can sometimes be the only people who make sure that criminal and civil attorneys are in touch with each other and are aware of what is going on in all court proceedings. Advocates can be amazing bridges. Just another assumption that I think I've made before, and certainly I think a lot of practitioners make, is that both criminal and civil attorneys are always going to affirmatively look for what is legally going on in their clients' lives. But the fact of the matter is that, you know, maybe while a defense attorney should actively be asking questions about whether or not their clients are involved in civil proceedings, sometimes it's hard for them to see past the criminal case that is in front of them right there. So somebody's kind of got to have their eye on all these systems at once, all the ways that they intersect in a survivor's life, and advocates can really help survivors do that and make sure that their attorney, all of their attorneys have all the information about everything else happening so that things can be ordered in ways that maximize the chances for more just outcomes. Explaining the details of each process, that's always something that advocates, particularly legal advocates, are very, very helpful with. And when people are involved in more than one proceeding at once, there's definitely another layer to it. Because people involved in multiple court systems really need to know how those systems might be similar and how they might be different. Again, this is true for everybody who's involved in multiple systems, but for people who are defendants, it's particularly important because there's rules that can impact somebody's freedom when it comes to criminal court. So, you know, if somebody doesn't show up for a civil protection order proceeding, you know, there's a number of things that could potentially happen. Yeah, some judges might issue a warrant to get somebody into court, but a lot of judges are just going to make rulings in favor of the party who did show up. And even though those rulings might have detrimental consequences, they're not going to necessarily result in arrest and incarceration. Well, that's not true for criminal court. If somebody doesn't appear at their criminal court proceeding in which there is a defendant, there might be pretty huge ramifications for that. They might end up incarcerated until the outcome of their trial. And so understanding ways that that's different, you know, that can be really, really huge. The opportunity to be heard in court is something that advocates can go a long way into helping survivors understand. You know, survivors often find, survivors who are defendants find themselves in this position of wanting to heal, of course, and wanting to tell their story. And arguably, no court system is the ideal place to do that, but oftentimes civil or criminal court system on the side of the defense is one of the worst places that objective can be accomplished. So attorneys might advise their clients that they're going to be legally better off if they don't say anything at all. And advocates can be a really key voice in the ear of a survivor to explain how, you know, that's not an effort to silence, that's not an effort to deny their truths and their experiences of abuse. What that is a legal tactic to try to ensure that they get a favorable outcome in court. Civil, and then going over to the civil court proceeding, maybe that attorney is going to have the same tactic in mind, but as I talked about before, it's much more likely that a survivor is going to have to tell her side of the story. So getting these two pieces of conflicting information from two different attorneys in two different systems, can be really overwhelming and traumatizing and confusing, and advocates are in a pretty good place to help people untangle some of that stuff. And it's not easy stuff, it's complicated stuff, but advocates can really help survivors be positioned to ask attorneys the questions that they need to ask to understand that they're walking through the door with the most information that they can possibly have. Another thing advocates can really be crucial with is helping survivors manage their expectations about what the processes can give them. This isn't only true for defendants or respondents. This is true for anybody who is seeking relief in any kind of court system or is seeking an outcome in any kind of court system. You know, advocates who work with defendants often find themselves in the position of explaining that criminal court may in fact not be not only where their story gets told, but where they get vindicated. That might not be the place where people are exposed to the truth of the matter of what happened. That might not end up, you know, unlike what we see on TV, that might unfortunately not be the way that a criminal court proceeding goes forward. And in fact, a survivor might look at the realities of her life and what gets said on the stand in a criminal court proceeding and think that those are two completely different things. So to the extent an advocate can help a survivor prepare for that reality, whether that's in civil or criminal court, the more equipped that survivor is going to be. And also just what's possible. You know, lawyers are explaining this stuff too, but advocates can really equip survivors with a lot more knowledge about what each system can give and what each system can take away. You know, if a survivor is petrified of receiving a jail or a probation sentence, and, you know, she's having a hard time helping to defend herself in civil court, you know, advocates can be there to say, you know, look, the worst thing that can happen here today, you know, at least as far as the judge goes, is that you get this order issued against you. You know, that can go a long way into managing anxiety and to, you know, really giving the survivor the tools to participate in her own process, participate in her own defense. There's going to be a million situations, of course, where we're not always able to get all these magical lawyers that I've been talking about for the last 90 minutes. And when that happens, that doesn't mean that there's things that advocates are, you know, completely out of it. There's a lot of things that advocates can still do, and they don't give rise to the level of illegally practicing law or anything like that. Advocates can have conversations with defendants about how to approach the court to try to get a continuance. And the best way that they can do this is to know how it works in their communities. There are definitely some places where civil judges have zero interest in hearing a protection order proceeding until related criminal proceedings are resolved. And so if you're an advocate working in a community like that, the survivor needs to know what paper she needs to file or who she needs to get on the phone to make sure that that civil case doesn't happen until the criminal case is over. And then again, there's also communities in which some of these risks about incriminating yourself, you know, aren't such a major scary thing for survivors because there's laws that say that what happens in the protection order case can't actually be used in the criminal case. So if you're in a jurisdiction like that, and you have that kind of proceeding, making sure that the defendant knows about it and makes decisions about how her cases move forward, having that information can also be something that's extremely helpful. We hear from advocates a lot who are working with defendants who have decided, look, I want to get a protection order. That's what I want to do. And it's just so important that there's somebody there to talk with them about all the potential downsides of seeking that protection order, as well as the upsides as well. These are conversations that advocates have every single day, obviously, but it's important to make sure that the particular issues that come up when somebody has an open criminal case end up being part of that conversation. One of the considerations that I think is huge is whether or not, you know, if you get arrested and then you go ahead and file a protection order, are you just going to look like you're retaliating and then appear to be less credible? Because that's definitely something that can undermine how somebody's believed as they move forward through their various systems. Oh, she only filed that because she was mad she got arrested, is how that tends to go down. The incrimination piece is going to be another consideration to think about before actively trying to seek a protection order. And then whether or not any conviction that results from her criminal case could end up being used against her in the protection order proceeding. You know, there's a lot of important considerations. These are only three. And sometimes, you know, you're going to kind of run through these things with a survivor or with a survivor and her attorney, and she's still going to decide what she wants to do is go ahead and get that protection order. And so when that happens, you know, encouraging the defense attorney to take whatever active role he or she can take in what that petition looks like can be something that's enormously valuable. So just noting the time, I'm going to pause now and you know, at least try to answer as many questions as came up during this proceeding, if I can.
Great. We have 6 questions so far for you, Cindene.
Okay.
I'll go ahead if you're ready.
Sure.
Yes. One of the first questions is regarding consenting to a protection order. So many jurisdictions have it where you can consent to a protection order and there's no findings of fact of abuse entered against you. So the question is, how does the criminal system view consenting to a protection order? In this particular participant's case, their courts, at least, a consent agreement means that the court finds no evidence or guilt, or what we would say no finding of fact entered indicating that an incident of abuse has occurred under the protection order statute. So is there a difference in the view of the criminal justice system in whether or not it's a consent with no findings versus a hearing in which the court enters an order against that person?
Yeah, I think those can be pretty different situations, and when somebody consents to a protection order and there are no findings, what that's going to mean is that there's nothing on the record, right? And so there's not going to be any facts that can be used to support a criminal case. I think that's absolutely true, and so for some people, consenting to an order might legally be very appealing, but I would just caution people to keep in mind that even though there's not going to be findings of abuse entered against them, there's still going to be the risks that we talked about, the impact on credibility that might come up, and keep in mind, all the ways in which the criminal case might be impacted, if not directly by bad facts on the record, but from the side, because of the batterer's ability to manipulate easier arrests now, to get, the cops to respond in a different way now, to taint the survivor's credibility. Oh, she agreed to a protection order. We all know what that means. So just because there's no findings on the record, I think doesn't mean there's not going to be an impact on a concurrent criminal case.
Our next question is, why do so many family courts have the ability to override a protection order? In this participant's situation, they're seeing there's more and more leaving the survivor in fear and in a dangerous situation, and that the children are being used as pawns.
Actually, Monica, do you want to take that one? I don't want to talk out of school, and our expertise here at the Clearinghouse is really in the criminal piece of it.
Well, I think with this question, maybe we would need to know a little bit more information. What we see and what I've seen in my practice is sometimes a protection order is issued and the custody provisions within the protection order are modified based upon the jurisdiction of the family court. I'm not quite sure if that's what the person is referencing to. So that's going to vary by each statutory jurisdiction whether or not they have the ability to modify a protection order. I know in one jurisdiction that I practice in, they absolutely do have the ability to modify certain elements of that protection order regarding custody. But if that individual person wants to reach out to our organization, we can get more details and talk to them specifically about that question. Our next question is regarding, are you aware of any states that define which order takes precedent other than the California state that you have previously referenced?
I don't. California is the only one I've heard of. That doesn't necessarily mean there aren't other states with similar statutes out there. I would encourage people who are participating in this webinar to chime in the chat box if you come from a state where you know that a statute like that exists. That would be really helpful for all of us.
Our next question is, what should a victim do if they don't have the means to hire both a civil and criminal attorney in one of these situations?
Well, if somebody doesn't have the means to hire attorneys, I would definitely hope that there is a solid system in their communities for having criminal attorneys appointed to represent them, whether that's through the public defender's office or through a different court-appointed system, because in almost all cases, if you cannot afford a lawyer, one will be provided for you if, in fact, you're facing criminal charges. Unfortunately, that same right doesn't necessarily apply. It doesn't apply at all in civil cases. And so if you've tried your local anti-domestic violence program and you've tried your local legal aid offices, then you come up empty without anybody to represent you. I would hope that survivors in that position who are forced to proceed pro se in the civil courts would make sure that their criminal attorney is aware of everything that's happening on the civil side. Sometimes, though not always, sometimes criminal attorneys can do little things to support the to help the defendant in the civil case, like telling them how to try to get a continuance or reviewing the petition for a protection order before they end up filing it, or giving other kinds of advice, especially when the cases arise from the same incident. So I would just really try to leverage the resources of the community, civil legal aid to try to get representation. And if that's not available, then to try to use the criminal attorney as much as possible, even for things that are in the civil system.
Okay, our next question comes from a participant that states that they were surprised by so many questions regarding the civil protection orders, and that they weren't aware that the orders varied by state. And in their state, once a person is arrested, on a DV charge, they're issued a criminal no-contact order immediately. And they want to know, is that the normal course in other jurisdictions?
That's very common in a lot of jurisdictions. It might not be called a criminal no-contact order. It might be called a stay-away order. And in a lot of places, you're not just going to see this in crimes involving domestic violence. You're going to see this in crimes involving any allegation between two complainants. For example, if somebody's accused of burglarizing a store, that defendant might have a criminal no-contact order issued against them, prohibiting them from contacting the owner of that store. So it's extremely common. It's probably more common in domestic violence cases, and I would call it pretty routine in most states.
Okay, our next question deals with modifying no-contact orders and facilitating a relationship between the public defender's office and the prosecutors. In several cases in this participant's state, they are facing situations that were spoken about in the chat regarding victims having being represented by the public defenders and seeking modifications of their criminal non-contact orders. But that the prosecutor's office is very reluctant to work with the public defenders. So do you have any suggestions to facilitate a beneficial relationship between the public defenders and the prosecutor's office and the court in general?
I think that's a really good question, and I think it's something that could have great benefit to many communities in many different circumstances. I actually really think that community-based advocates can be some of the people who do some of that bridge building between public defender's office and prosecutors' offices. I mean, I think advocates are often in a really good position to see nuance that the public defenders might not see on their own or that the prosecutors might see on their own. You know, for example, if prosecutors and community-based advocates already have a solid working relationship, advocates can be, I think, pretty crucial in talking with prosecutors about ways that, being a little bit more moderate about modifying some of these no-contact orders can actually increase safety for the parties involved. Advocates are the experts on that. Advocates often have the prosecutor's ear. So I think that advocates can really be crucial in building those bridges that the person asking the question was talking about. Now, that can happen through involvement on coordinated community responses. That can happen when community-based programs facilitate training opportunities and invite people from traditionally different sides of the courtroom. I think the advocates are the exact right people to start making sure that some of those bridges get built or, broken relationships get mended.
Cindene,
Yeah.
I also have another question for you. What if the public defender's office is reluctant in working with a victim's advocate in those situations? How can you open up that communication and get the public defender to work with that victim advocate to help that survivor that they're working with?
Yeah, again, Monica, that's a really good question, and I know that we definitely spend a fair amount of time here at the Clearinghouse talking about, creating those relationships. I mean, I think, unfortunately, I think in a lot of situations, it's the advocacy programs who end up taking the initial steps to help those relationships. Sometimes that happens because advocates reach out about a specific case. In fact, that's how it often happens, building relationships kind of one case at a time. But once that happens, once an advocate a victim advocate has a contact in the public defender's office, that can open a world of opportunities for situations to sit across the table and talk about ways that they can work together to, protect the legal rights and options of their mutual clients. Cross-training opportunities really do work. Making sure that public defenders have, not just public defenders, but private attorneys too, have information about what advocates can and can't do. That's the kind of thing that really works too. Dismantling some of the myths about what advocates do can be helpful for the defense bar. I talk all the time about how, I was a public defender for several years, and I did not know that one of our local community-based advocacy programs was not a part of the prosecutor's office. So, making relationships, having cross-training opportunities, and paying attention to, how advocates and defense attorneys are perceived by each other, I think those are the things that can really foster those relationships. Are there more questions? Because if not, I'll just do a couple things to wrap up here.
I believe that is it. Let me just give everybody a second just to make sure there's not any other questions that I possibly missed here.
Okay. While you do that, I just want to encourage everybody to give us a call here at the Clearinghouse if you're working with a victim defendant, whether it's for a specific case or whether you have questions about doing defense-based advocacy in your communities, whether you're working with people who are reentering from jail or prison, or whether you just like more information. We would definitely love to hear from you. There's two resources I want to mention right now. One of them is in that materials pod, as Carrie mentioned at the beginning of this webinar, and that's a paper that kind of outlines everything I've talked about here today. I would encourage you to print that off if you would like to and take a look at that. There's also a question in there, or a section in there that gives some frequently asked questions and answers. And I would also really encourage you to take a look at our website and open up this toolkit for systems advocacy on behalf of victims of battering charged with crimes, which was written by our director, Sue Ostoff, and Jane Sadesky, who consults with us. And there's just so much rich information in here about how to increase the response to victim defendants in your various communities.
Thank you, Cindene. We don't have any other questions. So at this time, I'm going to turn it back over to Carrie for some final information for our participants.
Great.
All right, thanks so much, Monica, and a big thank you to you, Cindene. Looks like there are some more questions coming in. Please feel free to reach out and to NCPW. The contact information is right up here on your screen, and it's available on your PowerPoint. So if you don't jot that down now, you can grab it later. And just a reminder that I'm going to send out an email to everybody thanking you for your participation. The service as verification of your attendance, so hang on to this. It will have a link to where this recording will be posted and where you can access the previous webinar recordings, and this is what will be sent to you, that link there. And once I close, an evaluation will open up automatically on your screen, and we really appreciate any feedback that you can give us. And with that, I'll sign off and send one more big thank you to all of you. Take care, everybody. Bye-bye.
Bye. Thank you, Carrie.
Conference will automatically end in 60 seconds.